that way. So that's the difference. Video is live, phone is not live. But there will be 3 hours of credit, half an hour or 0.5 is in ethics. Rachel Fletcher Cipollette will be here at the end to tell you all the things you can't do that Chuck tells you that you can. I mentioned to those of you who are in here, if you're asking a question in the room, these people will come up to our speaker and ask it. But if you are online or on phone, you should either text me or email me. The text number is 304-546-7915. My email is caseya@wvbar.org. And when you send me a question, don't say, I have a question about something. Send it to me in the form of a question so I can repeat it to the speaker. I may not know what you're asking. So don't say, ask him a question about this. Phrase it with the question mark at the end so I can just read it to the speaker.
Can you repeat the text number?
The text number 304-546-7915. So we will have a 75-minute presentation. We will take a break, and then we'll have an hour and a half-hour presentation. Again, it'll be 3 hours credit. You do not need to do anything to report your time until you get an email from Mike Mellon. Mike is our tech specialist here. He will send an email to everybody who is logged in. We have over 300 people who are participating in this seminar. So it'll take him a while afterwards. So a few hours, maybe by the end of the day today, you will get an email from Mike. If you don't get it today, wait until tomorrow morning, look in your junk mail before you start calling. If you don't have it by tomorrow morning, say 10 o'clock, then contact the office and we'll get it to you. But when you get that email, if you were here for the whole presentation, click accept and it will immediately go on your transcript. If you had to leave early, adjust the time and then accept it. If you don't accept it, if you just let it sit there on your computer, it will not go onto your transcript. So be sure when you get it, read it, make sure your hours are correct, and then accept it. And then the next day, if you're concerned about it, check your transcript to make sure, but it should automatically go on there within, it should be real time. But give it, as always, give it, about 24 hours just in case something gets stuck in spam. With that said, I'm going to turn it over to Chuck Johnson.
Thank you. Good morning, and we're pleased everybody can attend both here and remotely. We're going to have a nice discussion today about medical cannabis and the future in West Virginia with some focus on certain issues. The panel discussion is intended to allow you to have some understanding about what's going on with the medical cannabis laws and the program. And Jason Frame, who's the director of the West Virginia Medical Office, West Virginia Office of Medical Cannabis, is unable to be here. Brian will tell you why, but he has a very good reason. Brian Skinner is here as general counsel, and he's going to fill in for both of those roles. And we also have, on behalf of John Perdue, as the West Virginia Treasurer, we have Diana Stout as general counsel to serve in that role. And so we look forward to the panel discussion. We're going to talk, I'm going to speak after the break on, some issues related to financing, investing in medical cannabis, and certainly you guys can understand it's been in the news this morning and it's a timely issue. And then Rachel Fletcher Cipollette is going to deal with, the ethical issues and attorneys representing medical marijuana related businesses and the recent change to the rules of professional conduct to address that. So I think the issues are very timely. We encourage questions. I think for the initial panel discussion, what we probably should do is allow them to get through some of their discussion, and then we'll open it up. But I suppose if there's a timely question, feel free to ask it. But we're going to try to get through some of that presentation first. So I would like to introduce Brian Skinner as general counsel and welcome him.
Thank you. I'm going to go through the act. It was enacted last year in 2017. And then as you mentioned, it's Jason Frame, really the only employee of the Office of Medical Cannabis at this point. We've had a little issues getting it up and running, and I'll go through a little bit of that in a few minutes. But he had the unfortunate occurrence of getting hit by a car, literally hit by a car yesterday on Virginia Street as he came back from the bank. And luckily, he just didn't get pinned between the car building where the car ended up. So anyway, he apologizes, but he hopes you understand he's not feeling real well today. So how do I just use this left and right? Okay. So Senate Bill 386. It was enacted by the legislature on April 6, 2017, signed by the governor on April 19th. And a little bit of the history. Originally, 386 came over from the Senate. It was a majority vote, of course, well received by the Senate. And in fact, that bill had the ability of individuals to grow their own in their home, I think up to 3 plants. It also had a commission set up. When I got over to the House, it ran into a roadblock. But one of the things, I was at the legislature on House Judiciary for 12 years. And I was at the Bureau for Public Health in 2017. But what I witnessed, it happened there was something I hadn't seen in over a decade at the House of Delegates, and that was a bill being discharged from committee onto the floor and taken up. I had not ever seen that. Normally that is, that's so amazingly rare that you can beat that. Normally the majority can at least beat down a motion to discharge, but they didn't. And in this case, they got a reprieve. House Judiciary went and reworked that bill. And what you have is the current Medical Cannabis Act, which is nothing like the bill that came over from the Senate. I will say the bill that was passed by the House is almost essentially Pennsylvania's law. It was over a weekend, and I'll give kudos to the staff at House Judiciary who was able to take the Pennsylvania Act, which was about a year ahead, and rework that. But essentially, it's Pennsylvania's law, which has been helpful to us at the Bureau because we have at least Pennsylvania a year ahead of us to sort of model ourselves on. So essentially, it authorizes under limited conditions the use, possession, growing, processing, dispensing of cannabis for the treatment of serious medical conditions. These are the serious medical conditions. There are 15 of them. Again, they're essentially, there's a little bit of difference between West Virginia and Pennsylvania, but that's essentially they're essentially the same. Terminally ill is you have a life expectancy of less than 12 months. So the Uniform Controlled Substances Act is sort of a problem, but here the manufacture, distribution, possession, processing that are in compliance with the Act are then exempt from the provisions of the West Virginia Uniform Controlled Substances Act. Federal law still prohibits. It's a Schedule I substance under federal law. And as you may have heard recently, that's, and I'll get a little bit about that, that's really the basis for our slow movement in getting this act implemented. So lawful forms, not every form of medical cannabis is legal in West Virginia. The forms are specifically set out by statute. You can see them there. At the bottom, it notes that dry leaf or plant form is illegal still in West Virginia. The interesting thing is that that can be placed on the list of lawful forms by a legislative rule adopted by the Bureau. And I'll get into how that will happen, but it's kind of interesting that the Bureau add dry leaf based on a recommendation of the Medical Cannabis Advisory Board, which I'll get to at the end, could add that by a legislative rule. Now, of course, that legislative rule has to go through the legislature, which could decide not to adopt the rule as proposed by the commissioner for the Bureau for Public Health. So lawful uses, so the Act establishes the lawful uses and forms. It requires registration of physicians who will be permitted to issue certificates to patients, allowing them to obtain the medical cannabis. They're not prescribing it. That's an important point. Physicians do not prescribe. It just issue a certificate that you have one of those serious medical conditions. Patients and caregivers then who would be issued an identification card by the Bureau upon receipt of that certification, and they can then purchase medical cannabis licensed dispensaries. And minors may also receive medical cannabis through this process, but they would have to have a caregiver who would be able to purchase it for them. Unlawful uses. You don't smoke medical cannabis under the Act. Again, that may change if the commissioner were to propose rules to make that available. You cannot sell edible forms under the Medical Cannabis Act, but it doesn't preclude individuals from buying those lawful forms and then incorporating it into food to aid digestion or ingestion of the medical cannabis. You just won't be able to go out and buy gummies. So under the Act, there are 3 entities which are collectively referred to as medical cannabis organizations. And those are the growers, processors, and dispensers. So each of those, there are annual permits for each of those entities. The application process requires the entities to go through extensive criminal background checks. There's processes to suspend, revoke those permits, and restrictions on who may hold those in terms of their ability to pass the background check. And we have proposed and promulgated rules. We have a 2-year window to propose rules and promulgate them without legislative approval. And those rules actually include some capital requirements as well. And I'll talk about why we thought we needed to do that here in a second. So there are limitations on permits. This is a big deal, actually, at least not only to those who might want a permit, but also to the Bureau. Only 10 growers. However, each grower may have 2 locations, 10 processors, and 30 dispensaries. And there are been only 5 per region. So we don't have any math whizzes. So we decided that 30 dispensaries, 5 in a region, okay, 6 regions, that sounds right. So that's how we ended up. It was kind of a foregone conclusion. It's kind of interesting it was phrased that way. Unlike the growers, a dispensary permit, an individual may hold 2 dispensary permits. However, a grower may only hold 1 permit, but it could have 2 locations. And processors may only 1 permit per individual processor. So the fees, initial application fee of $5,000, a permit fee of $50,000, and a renewal fee of $5,000. Again, these are annual permits, and that's for the grower processor. The interesting thing, and we realized the way that when we first looked at this, we thought we were going to be able to charge a $50,000 annual permit fee. We don't believe that under our interpretation of the statute, we're going to be able to do that, which has a huge impact on our ability to have a sustainable office. If you only have 10 grower and processor permits, it sort of limits the amount of cash to sustain the administration of the office. And as you'll see, it's going to take a lot to administer this program. So that was a surprising fact to us when we looked at it. Now we can charge an annual $5,000 renewal fee, but that $50,000 permit fee is only going to be a one-time. As long as you're able to continue to renew that fee from year to year, you're going to be at $5,000. Dispensary is a little lower at $2,500 and $10,000 if you have 2 locations. And so it doesn't, again, the way the bill's written, it's really interesting. As I noted that, so it would be $10,000 for each dispensary. I noted that a dispensary can hold, a person can hold 2 dispensary permits. So it's kind of odd the way the phrasing in the Act is set out per location. Growers can have 2 locations. So anyway, it's things we're trying to muddle through. Limitations on the permits. The dispensary may only obtain medical cannabis from a grower holding a permit. So this is a closed system. The medical cannabis has to be grown in West Virginia and dispensed in West Virginia, processed in West Virginia, except for the initial seed. Once you get a grower permit, you can bring seeds from out of state, but none of medical cannabis after it's reached maturity can come from out of state. So again, grower processors may only provide medical cannabis to a dispensary holding a permit, And the last thing is what is commonly referred to as vertical integration. There were efforts this past legislative session to get rid of this particular provision, which says essentially that a grower processor can't be a dispensary. And we've learned, and others have learned that looking at other states, that it makes a big difference. And I think you'll hear some discussion about this later about why that's important in making this sustainable for those who want to get into the business. So this is one of the things that makes this a very expensive proposition from the state's perspective, is that there has to be what we commonly refer to as seed to sale tracking system. So when organizations from growing to dispensing, they have to join this electronic tracking system, and that's one of the things that we're in the process of setting up. From the time the seed is grown, the plants have to be tagged, RFI tags. We have to be able to track from the Bureau. We have to be able to track that plant from the time it's grown through the time it's dispensed. So that is ensure that none of the medical cannabis gets outside of this system. And so that is as you can imagine, a pretty significant piece of software that all of the medical cannabis organizations would have to be a part of. And it would also allow the Bureau to be able to track the medical cannabis. So there is no diversion of medical cannabis, and know where medical cannabis is at every point in the chain. The Bureau is required to promulgate rules for the storage and transportation of medical cannabis. We have done that. In March, we filed our rules. They were emergency. Under the Act, we were given 2 years. Normally, we would have to bring those proposed rules before the legislature for approval, but the Act gives us 2 years to have our emergency rules in place before we go to the legislature for approval. The other part of this is the medical cannabis has to be tested, and so there will be a regimen of testing to ensure that the medical cannabis is safe from pesticides and other molds, funguses, etc. So we are contracting. We will also license laboratories where the medical cannabis organizations will have to have their product tested from time to time during the chain to ensure it's safe for consumption. The Bureau, along with the Department of Revenue, must monitor the prices of medical cannabis. And if we determine that they're unreasonable or excessive, we can cap them, those prices, for a period of 6 months, and they can be extended. That's an interesting thing because none of us at the Bureau know how much medical cannabis should cost. So that'll be a learning experience for us when we get to that point. There are taxes, and the Act provides for the collection of those taxes. There is a program fund that is set up with all the taxes and fees go in. Those receipts from grower processors, from the sale to the dispensaries, and it's taxed at a rate of 10%. It will be paid and charged against the grower processors, but can't be added to the price at the dispensary. So the patients won't be paying a tax, only the grower processors will be paying that tax for the sale to the dispensaries. And I think that's the reason for the lack of vertical integration, because it makes that process where the dispensaries have to be separate from the processors. It makes that a little bit more difficult to have any collusion.
They each pay 10%? Growers/processors?
Yes, for the sale. So the idea is that only the charge between grower processors and processors to dispensaries would be taxed, not the sales at the dispensary level. So before a permit may be issued, the Bureau must obtain the written approval from a local board of health in which the county is the grower processor dispensary is located. There also has to be a written statement from the county commission in which the permit is to be located. County commissions are authorized by the Act to pass an ordinance restricting or zoning medical cannabis. If they decide to prohibit medical cannabis organizations from operating in that county, they have to do a referendum, a vote of the people. Municipalities may also zone and prohibit, but they don't have to have that, the vote part of it just can be by ordinance. But counties would have to have, if they decided to prohibit medical cannabis organizations from operating in the county, they would have to pass an ordinance and have it voted upon by the voters of the county. There are prohibitions on public officials having an interest, a financial interest in medical cannabis organizations or having family members employed by medical cannabis organizations. So then there are the patients. Patients have to get the physician certification that they suffer from one of the 15 medical conditions. Again, it's not a prescription. So they're only saying that you have that, that particular serious medical condition. They can, in the certification, indicate how long the individual may have that condition, so they could restrict the amount of medical cannabis and the duration of the medical cannabis. The patient identification cards are 1 year, so they have to be renewed each year. But in this case, so while it's not a prescription, the physician can at least limit to some degree the amount of cannabis and for the duration of the medical cannabis. So then once the patient has the certification, they come to the bureau and are issued a medical cannabis identification card. So with that card, they would then go to one of the permitted dispensaries and receive their medical cannabis.
Brian, could I ask a question that's somewhat related that it just came in? Why is marijuana in its dry leaf form excluded as a lawful means of industry medicine when doctors almost universally agree that marijuana in its natural form is the most beneficial for medical treatment?
It is because the legislature says we cannot provide it in dry leaf form. So I'll get to, we'll talk about this a little bit, but there is an entity called the Medical Cannabis Advisory Board, which has the charge of making recommendations to the commissioner. And one of those recommendations to the commissioner is to add dry leaf. So it could happen by a proposed rule from the commissioner for the Bureau for Public Health and be added. But at this point, the legislature has determined that it would be unlawful to provide dry leaf or plant form and to smoke it. Now, I will note that one of the forms is nebulization, and so you could buy potentially, and I don't know anything about this, but it seems to me that there are certain oils that you could nebulize, which is sort of like e-cigarettes. And so while that wouldn't be dry leaf or necessarily smoking it, it may have the same effect. But
is the advisory board going to have public meetings where the public can have input on this?
Yeah, not only, yes, they have. We have met
Can you repeat that question?
Okay, I'm sorry. The question is, will the advisory board have public meetings? And they have. The advisory board has met on 4 occasions already.
Are they going to have any future ones as far as developing the rules?
Yes, there will be future meetings. We have, and I'll talk about this in a minute, about the current state of our program, and as a result of some things that have happened at the legislature, we have had to slow down, and so we are kind of in a holding pattern right now. But yes, in fact, there are subcommittees of the advisory board who are meeting. One of the subcommittees is dealing with the issue of what types or forms of medical cannabis should be added to the current statutory list.
One more question, if you don't mind. Did I also understand correctly that the legislature passed this law without even any consideration of what the final product will cost the patient at retail, with all these requirements of testing, tagging the plant, and $55,000 up front, and another $5,000 every year? It would seem to me that this would be an extremely expensive product. And then on top of that, you have to have pharmaceutical companies involved to create the oils, all the legal forms. So did I understand correctly, the legislature didn't even consider or investigate what the final product would be?
So I'm not sure I can restate that question. The question is, Did the legislature consider the cost of this program not only to the state but to the patient? No?
The cost of the final product.
The cost
retail,
of-
if I have one of those
No.
conditions and get all the requirements, how much will it cost me for an oil, all the legitimate forms? That's
So the
my-
question is, how much, did the legislature consider how much the final products were going to cost to the patients at the time they're dispensed? I can't say what the legislature considered. What I will say is that this bill was drafted over a weekend, taken up on a Monday, and passed. So I would suggest that not a lot of consideration went into those sorts of issues. In fact, I'll note that the permit fee in Pennsylvania, again, that this law is modeled on, is $250,000. So what they did consider was lowering the permit fees to make it easier for West Virginia companies and residents to involve themselves. So better move on, or I will not hit this. So caregivers are 21 years of age or older. You can have a caregiver. If you have a patient who can't get out to dispensaries, or if the patient is under 18, they go through a criminal background check. A caregiver can have up to 5 patients.
I have a quick question before you switch off that screen.
Yeah.
It said that a physician has to certify the condition. Can it be a mid-level provider like a nurse practitioner?
No.
Or a physician assistant?
Yeah. The question is, does it have to be a physician to make the certification? And the answer is yes. It has to be a physician. One of the things the Medical Cannabis Advisory Board can recommend to the commissioner is to expand the practitioners who may certify. But under the law, right now, only physicians may do it. They also have to have a treating relationship of up to 6 months. So you're not, under the act, you won't be able to go into a doctor one day and get your certificate and walk out. You're going to have a treating relationship with them. And the physician's going to have to make certain assertions in their certificate. So there's a question about physicians' willingness to do that. We don't know that yet, although we did a survey which suggested that physicians are looking at this favorably and are interested in providing these certifications.
One quick question, and then there's a loaded question.
Yeah.
Like, this one's not loaded. Who will the Bureau share the list of those with the ID cards with?
There are, the question is, who will we share the list of IDs? I'm trying to, there's specific confidentiality provisions. I don't believe that the patient list is FOIable. There were restrictions on what is accessible via the Freedom of Information Act. My recollection is that's not one of the things that is available. I think the list of physicians is, but I don't believe the patient list, patients who have been certified, is available via FOIA, but I can check that. I haven't had to think about that question in a while. Okay, so patients who are minors, that be a parent or legal guardian, individual designated, and the Bureau also may appoint someone if there's no parent or legal guardian appropriate or available. There's a provision in here for reciprocity agreements. It's very narrow, and so prior to the startup of this program, which I didn't mention, which is we may not issue identification cards until July 1, 2019. So in the interim, this provision is available, although it's pretty restricted. So the Bureau may enter into reciprocity agreements with other states who have comparable requirements to ours for the use and lawful purchase of medical cannabis, but only for terminally ill cancer patients, and that's someone who has a life expectancy of less than 12 months. To go outside the state and bring in medical cannabis. We have not been contacted about any state with regard to this provision. So at this point, we have not actually sought or been contacted by a state who would be interested in entering into one of these agreements. So the identification cards, we're currently working on a process, although frankly, this is down the line. It's always been our intention to get the growers, then process up positions, and then the identification cards, since that's the last thing we really need to have in place. So so we're hoping to make this available via website for people to apply, provide their certification. And as it notes, July 1, 2019, we can't issue the first card until that date. There's a $50 fee, although we can waive or reduce that based on the financial ability of the patient to pay it. The Act specifically tells us that insurance companies are not required to pay for this product. There are provisions requiring the Department of Education to promulgate rules regarding the possession and use of medical cannabis in their schools, on the grounds, by employees, by students. I noted that students, minors can use medical cannabis and be provided a identification card. So there's certainly an issue of potential of them taking it on the school ground. The HHR is required to promulgate rules for basically the same reasons. There's a lot of other provisions. There's criminal and civil penalties for violation of the Act. I didn't think I'd get into that. There are 2 articles in the Act regarding research by educational institutions and medical facilities to research. Those are way down the line, at least from the Bureau's perspective, in getting those stood up. And that is being pushed further and further into the future the way things are going. So the effective date, the criminal provisions were effective 90 days from which the passage, which was July 5, which was the effective date of the criminal provision. The issuance of identification cards, again, not until July 1. Everything else we have been working on, although at this point there are no applications for growers or processors, and therefore no permits issued at this point. So the administration of the program, as you probably guessed, is within the Bureau for Public Health. We have an Office of Medical Cannabis. Jason Frame, who has been selected as our director. We have rulemaking authority, including emergency rules, as I noted. We had 6 months from the date, the effective date. So we were supposed to file emergency rules in January. We were a little late on that. We didn't get them actually filed until March. We went through a process of public comment. We did not use the Administrative Procedures Act, West Virginia Administrative Procedures Act rulemaking article to do that. So we didn't file them and through that process because we believe we have an exemption to that for 2 years. But we did put them out on our website. We made them available. We made them available to the Medical Cannabis Advisory Board. And so they were all, we got a lot of feedback from those individuals, not only who were interested in being patients, but entities that were interested in being one of the medical cannabis organizations. So we're in the very early stages of this now, and so our rules are out there. We expected to be issuing applications the end of April. We were gunning for April 20, but that didn't happen because the, first of all, issues came up about the ability of the Treasurer's Office to accept and process application fees. And since if we don't have the ability to take fees and process them, and as a result of the unwillingness of banking institutions to accept this money, because as I noted, and as you are well aware, under federal law, it is still an illegal substance, and the funds derived from the manufacture and sale of that would certainly subject you to criminal liability. So banks were unwilling to be involved in this at this point. So that has basically put us in a suspension of proceeding on the application. They're all ready to go, but we have to hold those since when we receive the checks, we wouldn't know what to do with them other than put them in a drawer somewhere.
Brian, can you sort of give us an idea of once we get those applications in, the timeline, have growers and processors up and running, and growers and processors, and then maybe dispensaries, sort of how long it would take to flesh out the whole, your view?
Yeah, let me get, when I do Jason's part, I'll touch on that because that's part of what Jason was doing. So real quickly, certification of patients, MDs and DOs must be licensed in West Virginia. Then you have to register, physicians have to go through a 4-hour training that the Bureau has to put together before we will put them on the registry, which would allow us then to accept a certification that they would provide a patient. So the Office of Medical Cannabis would then register practitioners, ensure compliance, 4-hour training, which would include the latest scientific research and the risks and benefits of medical cannabis. The boards would have to approve continuing education for this training. This is the registration and eligibility for being registered. It's an annual review of the license. They have to be licensed, and the licensing boards have a duty to report lapses in license. They have, physicians have an ongoing responsibility to report if a patient no longer has a serious medical condition or would not receive any therapeutic or palliative, or the patient died. So there's a duty of the physician to follow up. There's restrictions on practitioners about being involved with medical cannabis organizations, sort of direct them into the various organizations. And they also may not hold any direct or economic interest.
I have this right there. How do you reconcile that with the dispensary must have a physician or pharmacist on site at all times that it's open? Are physicians just going to volunteer? If they're on site, they're ostensibly getting paid. Therefore, they have an at least indirect economic interest in the operating of the dispensary. Therefore, well, there's just a.
So the question is, I haven't gotten there, but dispensaries have to have a physician or a pharmacist on site during the open hours of the dispensary. This restriction indicates that a physician may not hold the direct or economic interest in medical cannabis organization. Certainly would suggest that could be a problem. We haven't gotten there yet. I think that we would interpret the statute in a way that could give, that could allow both of those things to be true. So while they could employ the employment of a physician or a pharmacist to be on the site, would certainly suggest that they have an economic interest in it, but that employment relationship we would approve. We wouldn't allow a physician to have an investment in the medical or own an investment. I don't know how else we could do that and give effect to the statute other than say only pharmacists can be on the dispensary site. And so I don't think, again, we recognize the way this bill was written in a very short period of time, there are some consistencies in the way that it's written. So that's we'll have to deal with it when its time comes.
I want to hold this question because when you said don't know what to do with the check, I'll save those for Diana, but who's going to speak to the appropriation for the implementation and what's going on with that?
I'll talk to it. I'll say something about that. Yeah.
Okay.
So again, I've sort of gone through a lot of this, the certification issues, and then we would issue, again, has to be under continuing care. We realize this is an interesting thing. West Virginia has a lot of veterans who seek care at veterans hospitals. This is going to be difficult for them, we recognize, because veterans hospitals are probably not going to be permitted, physicians who are employed by veterans hospitals are permitted to do certificates. We don't know that, but we have a concern. So if a veteran is seeking and is getting their care from a veterans hospital and the physicians aren't going to give them a certificate because of the federal prohibitions, it could be tough for veterans to be able to make use of this system. And so we're not sure exactly what to do about that. This is the contents of the certification that the physician would issue. Again, these are the duties of the practitioner. They have to consult the PDNP when issuing the certification, when recommending any change in amount or form. They must give due consideration to other controlled substances that the patient may be taking. Give a copy of it to the patient, one is sent to the Bureau, and it has to be in the patient's medical record. And they may not issue a certification for their own use or for a family or household member.
Right, I teach fourth grade, I can talk about. Right now, there is a, in the law, it says if you have chronic pain and you're certified, you must try opioids for 6 months first. Is there any chance that will be stricken from the law?
Oh, my God.
Well, I'll talk about that a little bit. There were some efforts in the most recent legislative session to make some changes to this. Unfortunately, they hit a roadblock. Yes, there are lots of things in this act that people want to, but that was one that was definitely identified early by some folks in the House in particular. But unfortunately, those changes didn't make it to the finish line. So the duration of the medical cannabis form, it's only a 30-day supply, although during the last 7 days, you can re-up your 30-day. And so you can continue getting those 30 days through the valid identification card. Special conditions, you again specify a date certain, which it'll expire, that's less than the annual certification. And may include any requirement or limitation. Again, to point out, not a prescription. There are some prohibitions in operating motor vehicles or using chemicals which require a government permit. There is a THC limitation there in your blood serum. So may not perform employment duties at heights or in confined spaces. The employer may prohibit an employee from any task if the employer deems like threatening, and a duty which could result in public health or safety risk for being under the influence of medical cannabis. So the last pieces are the dispensaries. They may lawfully dispense it. They must provide the patient or caregiver a receipt that includes this information at the time they dispense. Physician or pharmacist on site. Pennsylvania allows registered nurses and PAs. West Virginia is more restrictive in that. They have to be there on all hours in which the dispensary is open. And they can't issue a certification there. So the physician can't be an office dispensary. You can't be issuing the certification and also having medical cannabis being dispensed in the same place or treating patients there. May not dispense a quantity greater than which as they've been permitted to possess, or a form prohibited by the law, or greater than a 30-day supply. There's got to be a safety insert that discusses the lawful methods for administering, the dangers, how to recognize problems by using it, and how to prevent or deter misuse by those who do not hold an identification card. It's got to be a sealed label package with that information on the receipt. Also, you'll note there's some warning statements about women consuming during pregnancy or while breastfeeding, the amount, and other warnings about being kept in the original container, and unauthorized use will subject individuals to criminal penalty.
A quick question that sits right there. Will an officer know the person has a cannabis card when running someone's license?
I don't know. That's a great question. Yeah, at this point, we have not had any discussions with law enforcement about transmitting the data from those who hold identification cards into any database. I will point out, though, that under the Act, law enforcement has access to all aspects of this, from the seed to sale through other parts of it. So I certainly can envision there being some transfer of information about who holds valid identification cards. So, yeah.
Question, I'm sorry. Do you have any insight on how they came up with that 3 nanogram level for operating motor vehicle? The reason why I'm asking, my understanding of anything under 15 nanogram was reported by the lab as a negative result.
I don't know. Pennsylvania, you could say. There are penalties for the criminal diversion of medical cannabis, violations of felony 1 to 5. Again, there is no criminal or civil protections for undertaking any task that would constitute negligence, professional malpractice, professional conduct. There are employment protections. Employers may not discharge for having the ability to use medical cannabis if you're properly certified, but there's no requirement of an accommodation on the property or limiting the ability to discipline for being under the influence. And it doesn't require an employer to commit an act which would put the employer or any person in working for the employer in violation of federal law. Medical Cannabis Advisory Board, sorry, it's so small, but that's the membership. It's led by my boss, the Commissioner for the Bureau of Public Health, and state police is involved, 4 physicians at various disciplines, pharmacists, pharmacologists, horticulturalists, a person designated by the West Virginia Association of Alcoholism and Drug Counselors, an attorney, a prosecuting attorney in addition to that, and then someone to represent the interests of patients. That board has met 4 times, I believe. We first met the board in September or October of last year. So this is the duties to analyze the law, analyze the laws of other states, accept written comments, although each of the meetings that we have, we take public comment, and we've had a meeting in Morgantown, we've had a couple of meetings in Charleston. We've been trying to put those around the state, and we will continue to do that. And then issue a written report, and those are the issues that the board, about changing the types of professionals, adding conditions or removing conditions, changing the forms, adding the number of growers, processors, and dispensaries, ensuring affordable access to it, and whether to permit the dispensing of dry leaf or plant form through vaporization, not smoking. Smoking will still be illegal. There are 4 terms. We staggered those. Again, the commissioner is the chair, and those are kind of standard rules. No compensation, and although we would reimburse expenses. So this is the important part. So those recommendations, which would happen, the board has 2 years in which to make these recommendations, can be proposed by the commissioner if the commissioner decides to accept them into a legislative rule. And then the notice of those recommendations would go to the legislature for promulgation of the final rules. So that's my part. Now, Jason was going to talk to you about the office.
Are those recommendations done and posted somewhere?
No, there are no recommendations yet. The caveat to that is this. Before the legislative session, we invited 2 members of the legislature, Dr. Ron Stalling, senator, and Mike Pushkin, delegate, to come and talk to the board. They asked the board going into the session if they had any recommendations they wanted to make going into the most recent legislative session in January, to go ahead and expedite their recommendations and provide those recommendations to them, and they could be incorporated into some legislation. And the board did that. It worked very quickly, and within a matter of 2 weeks made certain recommendations about what it thought changes should be made. The House did take up some of it. It is online. I'll point out we have a website, medcamwv.org. And those, our rules are up there. The rules are also on the Secretary of State's site. Also, that report and recommendations to the legislature are up there. And I'm not going to go through those. The House, a bill was taken up in the House. Some of those recommendations were in that bill. That bill didn't make it to the finish line, as I noted. So there were sort of preliminary recommendations. Dry leaf was not on there. There were some others in terms of some, most importantly, the most important one to the Bureau is the limit on permits. 10, 10, and 30 is huge to us. One, because it creates another level of concern if we get 12 applications that would be in any other, that would be acceptable, that would meet all the requirements, but we're only allowed to issue 10. We would foresee getting sued twice. And so we were hoping to expand the number of permits so we could avoid having to choose 10 out of applications that met all the requirements, but we just had to choose 10 out of 12. And so we were requesting, and the other reason is the fee issue, because we believe we're going to need money to sustain this office. We thought more applications, more permits would generate more income for the office. And so that was another reason we were all suggesting and recommending that either a cap go off and allow any number of applications and permits to be issued, and then let the market decide whether or not you could sustain it, or at least raise those to some degree that would give us a little bit more ability to feel like we were not going to have to choose and make a determination about 2 applications that were in all ways equal and would have been otherwise we would have permitted. So that was one of the big things that was in the bill, and unfortunately we didn't get that. So real quickly, the structure of the office, this is what we envisioned, start within the Bureau, but we've got the DHHR Cabinet Secretary. Those are the operations, and you can see this is really complex, from registration to compliance, to permitting. We also have to have, we have an Office of Laboratory Services, which would do the accreditation and certification of the laboratories. So the medical cannabis organizations would have to contract with laboratories, but those laboratories would have to be certified and inspected regularly by our Office of Laboratory Services. And so you can see it's a pretty extensive organization that we envision being necessary to implement the Act. So we have a website. This is where we're at this point. We filed our emergency rules. We were in the process until recently of getting a contract with a company to provide the seed to sale software, and that's kind of in limbo. Going back to a question before, when the Act was passed, the Bureau did not receive $1 in appropriation to implement it. Everything that we've done so far has been by cannibalizing our other offices to at least be able to hire a director and make the progress we've made at this point. This past session, there was a bill to make appropriations into the office, and the governor vetoed it. And so at this point, we don't have any money, at least has been appropriated to this office to do all what is necessary to get it up and running. And so again, we have been moving money around in DHHR to be able to take care of the needs that we have at this point. Again, we have a director, and that's it at this point. There's no other member of that office. I've been providing legal counsel to the office, but you'll back on that chart, we believe that legal counsel to this office is absolutely essential. So we have regions, we have studied the interest, we have our emergency rules. We're developing our web-based applications, and that we submitted that report prior to the session. We thought we were going to have applications up in April for growers and processors. Our timeline was growers, processors would be first. Our target is July 1, 2019. So we wanted to make those available in the spring. We felt like it was going to take, they have to be, once you get the permit, so we were looking at 60 days to being able to evaluate and issue permits, 60 to 90 days. Under our rules, you have, once you're issued a permit as a grower, you have 6 months to be operational. And that is a huge endeavor. You're going to point out, you can only grow medical cannabis indoors. So you're going to have a facility in which is completely indoor, which prevents any of the medical cannabis from getting outside of that facility. So security cameras, the whole 10 yards, to ensure no diversion of medical cannabis. And so it's going to be a big deal for individuals who want to get into the growing and processing to have the security, have the facilities large enough to grow cannabis indoors. We expect that we have 6 months under our rules to be operational. So they would be growing, probably it's going to take, and I don't know a whole lot at this point about growing medical cannabis, but we were hoping that medical cannabis would be in the processors within 6 months or so, which would give them the opportunity to get it on the dispensary shelves by July 1, 2019. So most of what is on this slide has not happened. We do have applications, but other than that, the rest of it is a standstill. The reason it's at a standstill is the banking issue. Since we can't take application fees, we've decided not to put applications out there. We at this point don't have, we are basically on a shoestring in terms of running the office at this point. So the commissioner made a decision that we needed to at least slow down what we were doing at this point and wait to see what happens. So there was a bill in the 2018 session that would have fixed some of these issues. It didn't take the cap off of the grower processor permit, but it did at least, I think it raised it to 50 or 60. So we felt good about that. There were some other things that would have cleaned up some of these problems. Unfortunately, the bill on the last night of the session didn't make it to the floor. And then as a result of that, the bill which was enacted that would have appropriated money was vetoed by the governor. So at this point, we're in hiatus.
What does California, Colorado, and Michigan do about that? They can be running wide open.
I'm going to defer to those who know more about the banking system. Yeah. So this is the seed to sale flow chart from cultivation to patient. And again, that system, you have to be able to track that plant or portions thereof all the way through its growing to processing to the final product. So this is all what this office will end up doing. And, things from looking at product safety, the inspections, and making sure the security, the shipments, and all of that is done without any diversion, and even product recalls. This was our first year work plan, and most of these things were implemented. But the part where it gets to issuing applications, that's where it kind of stops.
Brian, before you go,
okay.
I have a question. Don't know if you can answer it based upon prior comments. The 3 nanogram threshold for THC in the blood can easily be met by individuals who use medical marijuana without the individual using marijuana for multiple hours. If the medical marijuana certifications are available to police when they are getting pulled over for a minor traffic infraction, doesn't this mean that all individuals who use medical marijuana are entirely at risk for DUI charge, even when they aren't high at times?
I'm not sure how to respond to that. It sounds logical. Again, there are prohibitions on operating motor vehicles, just the same as alcohol. So, whether that threshold is easily met or not, I have no idea.
But there's no safe harbor there to protect.
Right.
And who are the two attorneys on the board?
Oh, Jesse Forbes is the attorney who is not the prosecutor, the attorney who has a knowledge of the industry, which is interesting because we don't have the industry. And I'm sorry, Boone County prosecutor. Someone help me?
That's good enough, Boone County.
Okay. Yeah, so they're the two attorneys. Jesse Forbes has been very active in dealing with a lot of these issues, so been very helpful to the board as well. So we are waiting now for a resolution of the banking issue. So I'll leave it at that. I think I probably took up way over my time.
I'm going to introduce the next section and let Diana Stout address the legislative efforts. And, you know, one of the things that I'm going to do in the next section is deal with the question that Ed Rebrook asked about what other states are doing. But now we're going to focus on what's going on in West Virginia. I'm going to introduce and let Diana Stout deal with what the proposals are. And so please bear with us. I'm going to cut right to the end of my presentation for a piece. Okay, what's going on in West Virginia? You know, we had the treasurer raise some concerns in March of this year about their banking vendors for the state refusing to accept deposits from fees and taxes from medical marijuana related businesses. And I think the treasurer raised some very genuine concerns. He then issued an RFI to solicit some ideas and proposals from those that would address these concerns, and that was in April. And so soon thereafter, he has recently proposed a couple of alternatives on how the state of West Virginia could address this issue from a banking perspective.
Can you back up and say the basis for the refusal? I mean, were there communications from banks, or that's what I don't understand.
Well, and I don't want to speak for the treasurer, but I understand from what has been in the press and what has been in his letters raising these issues is that the banking vendor for the state has indicated that they, because of their federal regulation, they do not believe that they could lawfully accept deposits. And so some people are looking at this issue as compared to what's going on in other states and saying, well, what's different here? And, you know, I think it's fair to say that we have a higher risk profile in the state for these issues. I don't want to speak for the treasurer's office. So I just want to outline this issue for you. There's two alternative solutions, and one is what you're calling an open or closed loop system, and one is a state bank within the treasurer's office, sort of based upon what North Dakota has done. And option one, there's a closed loop system. Option two is a state-owned or sponsored bank. And so the second option would obviously take some time and resources and put this horizon further off. I think these options were a part of the recent legislative efforts, which Diana Stout is going to talk to you about. And, you know, if anybody has a question about a closed loop system, payments can only be made within the network of individuals and entities that have access to the system. They would be designated, and there would be a lot of control on that system. They'd be able to monitor the financial transactions between the state of West Virginia and make sure they're all authorized and have some control over where the money's going and tracking and so forth. So, you know, there seems to be some good solutions here. I know there was some questions even in the press this morning as to whether this is going to be effective and work from Speaker Armistead even. So, you know, these are serious issues. The closed loop system would establish accounts by entities associated with medical cannabis, strong security and fraud prevention, robust reporting. And those are very important things for us to consider in addressing the situation. And there's also some discussion about an open loop system that would allow some payments outside the network, and then a state sponsored or owned bank as a part of the treasurer's office. So I just wanted to introduce that as a possible solution advanced by the treasurer for discussion. And I think Diana wants to tell us about the legislation and what the treasurer has proposed here.
Well, actually, I'd kind of like to start long before that because there were questions raised early on about what happened. I apologize, I'm cold. When the legislation was enacted in 2017, we were well aware of it and really kind of recognized it potentially could be a banking issue, but really watched all these other states and we saw what other states were doing. There were at that stage about 26 states that had implemented medical and or recreational marijuana authorizations in their states. So we just kind of were monitoring it very lightly. We weren't really paying close attention to it until the Bureau of Public Health sent us their statement of work to approve for processing because state law requires all banking authorizations to be done by the state treasurer. So when that came, we contacted our concentration account bank and our electronic funds processor bank. Both of them said, we will not process medical marijuana funds. So at that stage, the treasurer felt like he didn't have a real choice, but to let the stakeholders know that we had a problem. So then the question was, do we want to attempt to find a solution? And the answer was absolutely, because this is what the legislature enacted. This is what the treasurer believes that the citizens have wanted to occur. So we wanted to try to find a solution to this. So we studied it. So I'll take the state bank first as the option. Part of the problem we have with some of the solutions that other states have are, under state law, you have to be a state depository. You have to collateralize at 102% all the deposits of money of the state. That's a problem. Because if we can't get a depository, our current depositories, the ones we're currently contracting with, to basically do this, then that becomes another issue. So we ended up with generally the two options, a loop system and or a state bank. And that would require legislation. So with the state bank, currently there are many, many states and cities like New Mexico, Santa Fe, California, Maryland, New York State, Illinois, looking at creating state banks, but none of them have done that yet. In large part because the time and the capital that it requires to actually create a bank. Not necessarily a federal bank, even if you create a state bank under the Commissioner of Financial Institutions in West Virginia, there are a lot of hoops, a lot of collateralization required, et cetera, and the state really doesn't have a lot of that capital to basically just allow to be sitting there. So why we recommended generally the loop system. Open loop, closed loop. Most of the systems that you'll see that are being used by many of the states and cities, like Los Angeles, San Francisco, that have authorized medical cannabis and or recreational cannabis, are basically using, in some form or another, a closed loop system. So let me give you an example of what a closed loop system is. You get a gift card from Lowe's. You put $50 on it. So you go to Lowe's, you give it to your child, for example, you give it to your brother or your sister, and that the holder goes in. Doesn't matter who it is, holder goes in and has a Lowe's card. So they can use that for anything at Lowe's. But they can't go to Home Depot. They can't go to Ace Hardware. They can only use it in this system. That's why it's called closed. And this would be the closed loop system. Now, there are some exceptions to this to a degree, so that you could have the payments go to multiple people, but they all have to be participants with accounts in the closed loop system. Consequently, you have to have a banking solution within that because the state has clearly an interest in the collection of the funds from the application fees and the taxes. And the Treasurer's Office cannot do that without basic legislation for that. So we had proposed legislation for this, and we drafted something. Actually, I drafted something last Saturday, in a hurry because we had a request from the legislator to draft something and give them something so they might possibly be able to get something enacted this week when they were in special session. Well, they did cause it to be introduced, but it did not go anywhere. and exactly how that occurred, that's, it wasn't on the governor's call. When the governor calls a special session, only that legislation that's on the governor's call can be considered. Since it wasn't on the governor's call, it was not considered. But at least it's out there at this point, and it gives people the opportunity to take a look at it and refine it and fix the problems that people see with it. So I could go over the general premises of the legislation. One, it mandates a closed loop system. So we would have, the treasurer would have to create a closed loop system. However, we also are going to allow them to potentially deal with the unbanked problem. One of the issues that a lot of people have in this industry is they cannot open a checking account. They can't open a savings account. They can't send money out. They can't send it by ACH or by EFT or anything like that. So you have employees, for example, I mean, there are websites that have Bud Clipper for $50,000 as a trainee. Money is not a bad thing with regards to this in terms of the salaries that are being offered. And this is a very growth-oriented industry at this point in time. There are at least 8 or 9 additional states that are looking to enact some type of legislation in this area. Most of them, of course, are first considering medical marijuana and then ultimately potentially recreational. So everybody that's looking at this has the same issues with regards to it. So mandating that, we would basically allow them to pay their employees through this system so that their employees could get an account in the system as well and pay them with that. Because as it is now, they can't do deductions. They can't withhold Social Security or anything else, 941 taxes, et cetera, on employees. It's a very cash-based business. The Medical Cannabis Act that Brian talked about provides that the only way to pay for the fees and the taxes is by cash or by money order. Well, they're not going to get a money order. They're going to have the same problems of trying to get a large money order, $50,000 money order. They're going to have to walk in someplace with $50,000 cash because most of them are unbanked. So the concept here is that they can go to the third-party processor under the closed-loop system. They're going to walk in with their cash, and the third-party processor will have armed guards. They will have an armored car service to process and transfer the funds. This is not an inexpensive process, regardless of what happens with it. So the closed-loop system is going to have big expense. For example, I talked to Colorado. A lot of people think the credit union is the answer because Colorado created, I think it's called the Fourth Corner Credit Union. It basically took almost just a little under a year from the time that they decided to form one to the time that they were actually to create one and get a master account through the Federal Reserve. Time is really of the essence, so that's one of the reasons why we would like to bid out and obtain the services through a closed loop system. Effectively, what happens is people who deposit money, the entities that deposit money, have an ownership interest in whatever organization is created. Somewhat like a credit union in a way, as opposed to I have X number of dollars, you won't have that. You'd have X number of credits. And the same thing would work. We put in a confidentiality provision because we do not want people looking into seeing, well, how much money does such and such have in there? How much money, is in here and who all is listed in there? That's a problem for people. I mean, it is like their own bank account. It would be typically confidential if it were a bank account. So we put a confidentiality provision in the legislation. We also put a provision in there that said that the Commissioner of Financial Institutions in West Virginia cannot effectively do anything to limit or prosecute or inhibit, prohibit, impair the ability of a financial institution in West Virginia who wants to participate. Our hope is that we might have a state credit union or a state bank that might potentially participate. Now let's talk about some federal issues. Part of the reason that the banks don't want to do any of this is because there are federal regulations out there, as well as the Controlled Substances Act, that talk about how funds can be processed. Since then, the U.S. Treasury has come out with a laundry list of the ways things can be done, and that's being done by some of these institutions. Then General Sessions, Attorney General Sessions, rescinded what had been referred to as the Cole Memo. During President Obama's term of office, there was a memo issued by somebody in the Department of Justice by the last name of Cole, basically saying that there was an authorization that they were not going to prosecute anybody that was associated with state-run cannabis programs. And then Attorney General Sessions, during his, I guess when he was being confirmed, his confirmation hearing, he basically said he didn't believe that marijuana was what people thought it was, that generally it was a much more dangerous drug than what people considered it, and he was opposed to it. Subsequently, he issued a memo overruling, rescinding effectively, the Cole Memo. So now we have another issue, and there are more banks that are actually operating in various states that are withdrawing from this effort. It used to be they would basically kind of sit there through all the worries, but they're very concerned at this point about what's going on. Ergo, our two state banks that we actually contract with had the same issue.
Can you name those banks and?
Sure, they're statewide contracts, BB&T and US Bank.
And are there written communications between the Treasurer's Office and the bank? They say, no, we're not going to take
I
this
don't
money?
believe anything has been officially put in writing, but we have been told several times by representatives of those banks in various meetings. We put in also about unclaimed property. Since we run unclaimed property in the State Treasurer's Office, a lot of these people that are going to be actually patients in this matter may not be able to use all of their funds. They may pass before that occurs. So we want to make sure that the money goes back to them and their heirs. The concept of what we have is dealing with the unbanked. There's also an issue with regards to, and you may have heard about the Rohrabacher-Farr Amendment. That's basically part of the continuing resolution. We haven't had a budget for a number of years passed at the federal level. So starting in 2014, there has been language inserted into each of those continuing resolutions that basically says that the Department of Justice cannot use any of its monies to prosecute anybody related to it. Basically, it's operating within a state legislative unit. So whatever it may be, as long as you're complying with that state law. Now, they are going at overproducers, particularly in Oregon. West Virginia, a lot of people think West Virginia has the ideal climate for marijuana production, but evidently that's not true. It's in Oregon, according to the article. So we would hope that the closed loop system could be implemented probably in a period of 4 to 6 months. We have to fit it out, of course, and there we have had various interests. As was mentioned, we did issue an RFI in hopes that we would get lots of information. We had 2 entities that submitted, but their information was very, very limited. It really provided nothing more than what we already knew. Just gave us 2 names of potential vendors when we do bid this out. I'd be happy to take some questions.
Do you expect that this legislation will be reintroduced in the future, or what's the expectation?
My hope would be that that would happen. And there are some legislative changes that Brian mentioned that are needed. And so it's possible that it could be companion legislation with that. But until something is enacted with regards to the banking, we're not going to be able to do anything. And there's a program along.
Digital currency like Bitcoin?
Well, effectively, that's kind of like the chain technology issue is maybe somewhat exactly what closed loop is in some places.
I heard our local United States attorney on the radio the other day said he was going to enforce the marijuana laws.
Yes, he has said that repeatedly and tweeted it quite often.
We might be doing a lot of wheel spinning here.
Well, there's a lot of hope that, and there's federal legislation pending. A lot of people do not think that we'll get it enacted in 2018, but there is a lot of hope that in 2019 it will. I guess they're waiting for the election in November to find out what happens. But it's not just It's not just a Democrat issue or a Republican issue. There is strong support from federal legislators on both sides, as well as at the state level. Or they wouldn't have enacted the legislation to start with.
Thank you, Diana.
We have perfect timing for our break. We are going to take a 10-minute break. Remember, if you are in this room at the State Bar Center, if you want to talk about cases, please walk outside. I have set a timer. We will start again in 10 minutes. Okay, a long time. Oh, thank you. Well, they told me I would have had a presentation, but they didn't tell me to bring one, so I didn't. Oh, I'm not leaving.
My wife is her first young.
Yeah.
I got in the parking lot, said, waiter, come running out.
to our session, our second half of the session. Got to get everybody in the room here to say thank you. We received one question for Brian before, or actually received it after he finished, so I'm going to pitch it out to him now. Where's Brian? Oh, Brian. He's only open for one question and answer, and then Chuck gets it. How long do applicants have to fill out and return an application once they are released by the commission? Grower, processor, and dispenser.
Yeah, so we don't have a time frame one. It's going to be an online application, so everything will be submitted online. We've worked with our vendor, state vendor, to have that all available. So at this point, we're going to open up the applications. We have not put a close date at this point. Again, we have 10 permits that we can issue, so I think a lot of it determines on how many and how quickly the applications come in. But it'll be a completely online process, which is interesting. Going back to the question, the money issue, because the statute does say cash or money order. We have expanded that, at least in our interpretation and spirit of the act, to expand it beyond that. But it's just electronic transfers, because it would be difficult to do cash or money order on an online application, as you might guess. Anyway, hopefully that answers that question.
Thank you. And I wanted to say, as far as the meetings of the Medical Cannabis Board, I've been to a couple of them, and they're run very well. It's a very impressive group of people. They do allow for public comment. There's subcommittees that are studying some of the issues you guys brought up. And, go online and check out the website, and you can see how much impressive work has already been done by this board with very limited resources. So thank you already for the speakers. In my part, I'm going to try to deal with what's going on in other states as far as financing medical cannabis. I did have one question I'll deal with initially, because it's really sort of off topic, and just deal with it. But someone was asking, I understand, that what's the impact of medical cannabis on opioid abuse, and what can we expect with that? And I think I understand the intent of the question. There is a study out there, and basically in the July 2016 issue of Health Affairs, they had a study, and they looked at Part D claims data for 17 states. This was based on 2013 that were adopted medical marijuana laws. So, that was in 2013. It's a limited study, but it's sort of well done with the limited data they had. And they found that the Part D program, which is covering prescriptions for opioids, basically, saved $165 million during that period for the 17 states. And so the studies said that there's presumably less opioid dependency and overdose based upon the adoption of the medical marijuana law. It's still a tentative conclusion, but I think that's something that West Virginia could take to heart as it does this, given our severe opioid crisis. And that's the only study I'm aware of. So if anybody else knows of anything else, let me know.
I don't know the study, but there is a place in California called High Sobriety that is treating opioid addiction with cannabis.
That's interesting.
Mm-hmm.
I'm assuming it's a cash basis only kind of affair, but
I'm sure it is at this point, but maybe in the future.
Anita, trouble with Android.
Just hit the button until I get the enter. Yeah. It should be. Just keep talking on it.
Okay. So I'm going to talk about what's going on in other states with financing medical marijuana. And, one of the things you need to understand is that West Virginia has a different risk profile than other states with this issue, and it's for various reasons, as has already been alluded to. But it's also very interesting to see how other states have been able to make this work. There's a lot of different approaches. So you know, we've already had a West Virginia Medical Cannabis Act overview, and Brian did a very thorough job at that, and I'm not going to replow that ground. I'm going to give you some alternatives for financing, investing in medical marijuana. One of the things I want to talk about is the risk and rewards with these different approaches. You need to know if you want to invest or finance medical marijuana, what your state risk profile is where's the federal enforcement priority. So we've already talked about the Cole memo and the changes by Attorney General Sessions. I'm going to talk a little bit about that. And then you have to be able to have, any of these programs have to have what I call compliance on steroids. If you're going to be a medical marijuana business, you need to be able to say, look, I've got a set of policies that I can show I'm going to strictly comply with the Medical Cannabis Act in West Virginia. I'm going to comply with all the guidance out there that's still in existence from FinCEN, but have anti-money laundering policies. I'm really going to do this in a way to show anybody that comes knocking in my door that I am not only have a set of policies on the books, but we're actually doing it and can show you we're complying with the law. And that's really what anybody that wants to get into this industry should think about. It's just a real robust compliance system. And that would apply too for the financing of this. So, and I'm going to talk about some of the solutions in the post rescission of the Cole Memorandum environment. Those are the regions. We've already talked about that, but that's sort of how the dispensaries are going to be allocated across the state. And Brian talked about the forms. And, you know, these are the serious medical conditions that you have to get access as a patient. And the studies that were done show there's a significant need for this in West Virginia. So I think we can all appreciate that if we can get this program up and running, it's going to really fill a need for people that have these serious medical conditions. I'm not going to get into the physician registration and the other stuff that was talked about before, and caregivers, but if there's any questions, we can go back to this. You know, you get the application, you get it completed, you get approval, you still have to go through county commission and zoning, business registration, state and local taxes, how you're going to pay those, and compliance with a variety of other laws and insurance. So these are serious issues for anybody getting into the business of medical marijuana related businesses. And those kind of issues will extend out to other businesses, landlords, security companies, anybody else that's involved with this, you know, some of the professionals that get involved with medical marijuana and so forth. So, you know, this is good information for a lot of different people. Okay, the current state regulatory environment, I'm going to get into that. We have 29 states in DC that have adopted medical marijuana. 7 states in DC have recreational marijuana. 33 states have industrial hemp sales or laws. And so that's the evolution of this across the country. I think the state of West Virginia is being very serious about if we're going to do this medical marijuana program, we're going to do it right. We're going to make sure it's effective, and we're going to, you know, if you just look at the program, and I know it was adopted very quickly, but the tracking and so forth looks to be a pretty robust program. If you don't comply strictly with the Medical Cannabis Act, you're going to be found to be violating the law if you're in possession or control of those substances. So very serious for everybody, from seed to dispensary to people that use it, even if they're approved. So that's got to be underscored. And then the interplay with the federal and state laws, why we're here mostly, is a lot of people feel that this is sort of like straddling the fence. I mean, it's a little bit slippery, and when you fall, you know what happens. So, you know, obviously we hope that you'll take away from this some important lessons on this program. That's the reward risk curve. Really, that is effective in showing in which states who's entering the market, and the higher the reward, you know, the higher the risk. So if you're doing an industrial hemp farm, there's lower risk and there's lower return. Medical marijuana is in the middle. and the recreational is at the very top. So that actually affects the willingness of lenders to get into this market, as well as those that want to do the medical marijuana businesses. So that's just general economics, but it's at play here in West Virginia and how we roll the system out. Okay, you know, you need to look at what's happening in other states to see what's going to work here, and that includes industrial hemp, medical marijuana, and recreational. The general approaches in other states have been the cash economy, and there's a lot of reasons that doesn't work very well, but you know, one article suggested 70% of these businesses are still in the cash economy, where they do everything on a cash-only basis. And it's working, it's just not working very good. And so we have traditional lenders, credit unions that are in the market, and it's a surprise to some, but we'll talk about that a little bit. It's a small number, but they're there. Electronic payment systems and the closed loop or open loop system, that was discussed already. CalPay is what Hawaii is using, an app that you can use on your phone to pay for your medical marijuana. That's a new thing that was actually developed by one of the Colorado credit unions that got into this in a big way. So they developed that software, the app, and that's, I think, going to be used in Hawaii. So we'll see. Digital currency, the Bitcoin. You can have a Bitcoin ATM at a dispensary. Someone can step up and have $100 and they can buy Bitcoin, and then they can take that over to the dispensary and buy their medical marijuana. I'm not sure that's what's intended in West Virginia, but it does occur in other states. To get a Bitcoin ATM established, if you're the owner, and you could have different owners of those, you need you basically need a bank account to do that, though. You need some access to transferring the funds electronically. And so that is happening. And then you could have other commodities. If you're a medical marijuana business and you have problems with, what am I going to do with all this cash? You know, it's possible that you could park some of that in some of the other commodities like silver, gold, or so forth, Bitcoin, I mean, those kind of things. That's not a good solution, but it does occur. So, you know, as was said before, it's still illegal to manufacture, import, possess, use, and distribute marijuana under federal law. It's a Schedule I drug. It's still illegal under state law, unless you strictly comply with the Medical Cannabis Act. There's no state safe harbor there unless you comply with the new laws. And then the next part I've brought in here to say, under state law, it's unlawful to possess a controlled substance unless obtained from a valid prescription order. That doesn't cover medical marijuana, this piece, because you can't get a prescription for medical cannabis. So you have to rely upon the Medical Cannabis Act and the provisions there. And so, okay, here's what's going on in the federal government. I'm just going to go through this very quickly. But the guidance on the Cole memo came out 2013, and what it did is it said, this is the federal enforcement priorities we're going to adopt. And so if you're doing one of these things, which we think is more risky and more problematical, we're going to go after you. But if you're not, we're going to say those priorities are not, those are not the top of our priorities for enforcement. It never did say you're going to be a safe harbor, but it did say if you follow these priorities and address these in a serious manner, you're not going to be at the top of our list for enforcement purposes. And so what that was used by businesses in medical marijuana is they developed their programs for compliance around those priorities to be very effective in showing that, you know, we're not going to allow sales to, you know, cross state lines and so forth. And we can get into the detail of the Cole memorandum and so forth. But what happened is that soon after the new year, and I think it was right after California rolled out the recreational program, Attorney General Jeff Sessions rescinded the Cole memorandum. So it's created quite a a stir in how this is going to be addressed in the future. One of the other things that's still in place, and it's been referred to as the Rohrabacher FAR, and now it's the Rohrabacher-Blumenauer amendments. What that is when budget bills get passed, if that's included, there's a provision that says, you know, you can't use federal money to enforce the Controlled Substance Act in these specific states that have medical marijuana laws. So West Virginia is included in that list. And the most recent adoption of that, I think it was in February, extended that to September. So it's still in place. But if you're investing in this business or you're a bank, you know, that's very tough to put all these resources at risk, and you have to keep hoping every 2 or 3 months that it continues. There is a case out there, United States versus McIntosh in California, that says, you know what, we're going to enforce this prohibition against using federal money to enforce these provisions. So it did respect that bar, but that's just a temporary bar. So that's not much comfort, but it is in existence now for people. So one of the things that the Medical Cannabis Act has some state safeguards, and I think that was already referenced. There's safeguards for a lot of the licensed entities and healthcare providers, some. It doesn't, you know, we've had to address the ethical issues for attorneys separately, and that's going to be our last presentation. It's not addressed in the Medical Cannabis Act. But, you know, it's been talked about already. Our U.S. Attorney for the Southern District of West Virginia has adopted a very aggressive approach to medical marijuana or any marijuana. And he said he's going to enforce the law. And I'm sure he's reading the same script that Attorney General Sessions is. So that has created some sensitivity to this issue that may be even more heightened in other states. And it's part of the reason we're having the issues with financing, and we have some concerns that other states are plowing ahead, so to speak. But, you know, you've seen the alternative proposed by the West Virginia Treasurer. We'll keep our eyes on those. I'm here to talk about what's going on in other states and what might be for some other possible solutions, some of which has already been discussed to a certain extent. So, okay, these are this is the current federal enforcement guidelines from FinCEN. And so if you're a bank and you have accounts that may have involvement with medical marijuana, you know, these are what you have to file as far as suspicious activity report. And so if you have an account that has some suspicion that they're involved in medical marijuana related businesses, you file what's called a marijuana limited SAR. And that's, you know, that indicates that you have some suspicion about an account and they're doing some business, or you think they might be doing some business with medical marijuana. And that can come up for a variety of reasons. It can be volume of cash. It can be unusual transactions. It can be that the cash actually has a certain scent, which happens. And, you know, that's just one of those things that financial institutions are still required to do. The next one is if there's a potential violation of the Cole Memo priorities, it's called a marijuana priority SAR. So there's some, that is still in place, actually. So the Cole Memo is rescinded, but the Cole Memo priorities reflected in that, if you have an account, you're a bank, you have an account and they're doing something a little bit more than you're suspecting, they're doing something that makes you think they're violating the priorities, then you have to do that, and that's going to raise a bigger flag. And then finally, if they need to terminate a relationship with an account, they file a marijuana termination SAR. And so that's the biggest red flag, and that's going to get a lot of attention from folks that might want to enforce this. So, you know, the question is, you know, when the Cole Memo, let me see if I can the next slide. So you know, when the Cole memo was rescinded, and I think that was January 3rd or 4th of 2018, you had a group of federal congressional leaders that said, well, we just need to know, FinCEN, is your guidance still in place? Because the Cole memo is gone, what do we do? We think not having guidance is a bad thing for the system because a lot of the compliance programs are built up around this. And, you know, as of February 1, there was some confirmation. It was the Deputy Secretary of Treasury that said this is still in place, but they're considering what to do with it. So, you know, one of the things they could do is they could take out the reference to the Cole memo or have some other set of guidance there that they incorporate instead of that, or, you know, they could actually rescind that guidance, which would be a more open risk profile for banks and institutions. And, you know, there are some concerns that people are, because you're still required to report these, is this information going to be used now with the rescission of the Cole memo to prosecute people? And that's a concern everybody has, but the financial institutions are still required to do this. So it's still in place as we speak. It's under review. Some people have raised and said this is going to have a chilling effect on financial institutions, and some of these will likely what they call de-risk, which means they're going to start closing accounts. I mean, that's what that really means. And, you know, don't ask, don't tell if you're a financial institution is not a good answer. And neither does it work very well if you're an account holder and you go in and you don't really tell them what your business is, because once they know and they think you sort of lied to them, that your account's going to get closed. You know, so there's a lot of processes going on that make it very difficult to establish accounts. And, but I'm going to tell you what's going on across the country in other states. The first thing is, before I do that, is what's happening with the cash economy. You get a mountain of cash, you get people walking around with duffel bags full of it. You know, I'm sure that there are people that observe dispensaries and who's going with the cash and so forth that are have an intent to make off with some of that. So it's a very serious situation. Tax abuse is there. Compliance with all the specific requirements under our act would be tougher in a cash economy. You can imagine the state treasurer's office, someone dropping off $50,000 in, you know, 20s or $100 bills. Is, you know, how many people are they going to have to count this stuff, and so forth. Crime, it creates a problem there. It's unwieldy, it's unsafe. And just the record keeping and accounting for this becomes a problem. And so it's not the best answer, but it's 70% or 80% of the answer across the country is still how it's done. And, you know, I hope that, you know, West Virginia could decide we're going to go forward and that's how we're going to do it. I don't think it's the best answer. So what we're trying to accomplish here is a good effort. Traditional banking, there's a limited number of traditional lenders that knowingly and intentionally are doing business with medical marijuana related businesses. And it's more increasing in credit unions that are doing that. And part of it just goes back to that risk reward curve. And so it's a surprise to some. The number that was there in January 2018 is probably less now in the number of accounts. So some of my information that's dated, you just have to understand that. And let's take a credit union. I'll talk about one in Colorado in a little bit. They really have, just like the medical marijuana programs with compliance on steroids, that's how they can justify getting into this market. They have to have a very high compliance program to make it work on their end. So they have to have dedicated staff that deal with medical marijuana accounts. And they have to have a very thorough vetting process and a lot of things that they do to provide as much security as they can as they get into this market. And understanding it's still illegal under federal law. So the Safe Banking Act is something that if we could obtain passage, and I'm going to get into that in some detail later, would provide some relief for all these various programs, and that may be the ultimate solution. We're going to talk about that a little bit. And then I guess it's fair to say that the DEA has proposed to undo the Rohrabacher-Blumenauer amendment, to do away with that, and it's done that several times. So, you know, that's still the risk at the door. The Safe Banking Act, has been reintroduced several times in the past. It's been recently reintroduced in this March. And I think you got Senators Murkowski and Merkley that are highly involved with that from Alaska and Oregon, but there's various other people that are. It's basically a bill to create protections for depository institutions that provide financial services to cannabis-related businesses. And that would probably be broader than dispensary, grower, processor. You know, there's other related businesses, but, you know, of course, careful attention should be made to that definition if it would pass, and so forth, what's included and what's not with the protection. It says in most forms I've seen it, that the depository institution shall not under federal law be liable or subject to forfeiture for providing a loan or other financial services to a legitimate marijuana-related business. So, you know, again, the definitions will carry a lot of weight on what the parameters of that are, but that's sort of the purpose and intent of the Safe Banking Act. So if that were to pass this year, these problems might largely go away. I don't know if you agree with that, Brian. That's really eliminates a lot of these other strategies and how you proceed with this. So the Safe Banking Act says, you know, federal banking regulator can't terminate or limit the deposit insurance for an institution that serves legitimate marijuana-related businesses. Of course, the illegitimate or illegal activities would not be covered. You can't prohibit or discourage someone from depositing into your institution from a medical marijuana-related business. You can't recommend, incentivize, or encourage someone to not set up an account. It's just sort of intended to provide a level playing field for medical marijuana-related businesses. You can't take any adverse action or corrective supervisory action on a loan because they're a medical marijuana business. So that's some of the more detail in the Safe Banking Act, and that may alleviate some of the concerns that state vendors have. They may still choose, for public relations reasons alone, not to participate. I mean, that could happen, that we get the Safe Banking Act passed and you have state institutions still not willing to do this. But there may be some, either in the credit unions or banks, that say, we're gonna step up and do a very robust program for compliance, and we're going to do it as a service to the community. So, you know, there's still that dynamic. There is some stigma associated even with medical marijuana, and you can understand that position. You know, you want to, you're accountable to your shareholders and investors as a bank, you have to be sensitive to that as anybody could be. So.
Was that page 21? That is not my page.
You know, there's a couple of added slides to this, and to expand on things. If anybody needs that, I can send it to you, or we can get it out to you. I just added a couple of things to expand on it. So, I apologize for not mentioning that. So here's what, you know, let's say in January this year, we had 390 banks and credit unions across the country that have medical marijuana related business accounts. And so that's a surprising number to some people, but it is the reality. Now, the current number maybe, I don't know if it's half that, I just don't know. You know, they have relied upon the FinCEN guidance to mitigate their risks in establishing programs, and the FinCEN guidance is still there, but the Cole memo is rescinded. One of the examples, California has recently proposed a public bank to be developed to serve medical marijuana businesses, and that's not developed. They have the I think one of their future treasurer and another elected officials charged with developing that, but that's just such a, the capital involved and the time frame, it's just not going forward as far as I know, but that's out there. Colorado has, as we said before, they have an approved credit union has been approved by the NCUA, the National Credit Union Association, and I think they've been given a conditional account by the Federal Reserve. They don't have insurance in NCUA. So the history to that is that was litigation. And you know, to resolve it, basically, you know, the conditions are very important for you to know. So that was big news that, oh, we've got this approved master account from the Federal Reserve. This is a change in how they're looking at this. Something's happening. But if you look at the conditions, you know, this is what they told them on their conditional approval. You must meet Colorado Division of Financial Services requirements, including obtaining deposit insurance. You have to provide a letter from the Division of Financial Services that these requirements are met. You have to provide a letter as far as the deposit insurance. And you have to adopt bylaws that say you're not going to serve medical marijuana related businesses until it's federally legal. So the settlement resulted in a conditional approval that they can go out and serve, you know, maybe people that are advocating medical marijuana, but not medical marijuana related businesses. So it's not really a solution. You know, you go back to the Safe Banking Act, until that passes, they're not going to be able to do anything with that. And so, you know, initially people thought, well, here's a solution, this is going to work, and everybody's going to be, you know, very thrilled with how this is going to be safe and it's going to make the system work. It's really not a solution yet. Okay, I'm going to talk about what some of the credit unions do. One of the ones that is very impressive with their compliance program is Partner Colorado. And there was a lady that was involved in credit unions, and she was nearing retirement. And for some reason, she got into, there was interest in that credit union wanting to get into this business, and she developed a very sophisticated compliance program that would, in her mind, allow them to do this. I think in her view, it was really just an academic exercise, but the more she got involved in it, the more you know, enthusiastic she became. So she was one of the leaders in doing this. And they have a, I think it's a division called Safe Harbor Private Banking that is dedicated towards medical marijuana businesses. And, you know, she really got into the details about what are you going to have to show the regulators that review us that they're complying with the Colorado medical marijuana laws, and then they have recreational there. So, the state had a bit. And so that's what she did. And so they were one of the very successful entrants into the market. And they are now being audited quarterly instead of yearly. She's had a few subpoenas, but she hasn't had nobody as far as their accounts. She is the same person, I think, that got involved in developing the app that Hawaii's going to use called CalPay. So, you know, as far as people innovating in the financial end, she decided she was just going to do it and got involved in it, and that's what's happening there. MAPS Credit Union in Oregon.
Is it called Partner Colorado?
Yes, that's the main credit union, and they have a division called Safe Harbor Private Banking. And then MAPS Credit Union in Oregon, they have to report pretty strictly to Treasury on their accounts for medical marijuana related businesses, and they have quarterly financial statements, a lot of detailed requirements, and they're looking at de-risking or closing accounts with all these changes. So they got into this in somewhat a big way, but now they're debating their future with this. And a lot of these credit unions, what you'll see is they get into the market because they think they can do it, they think there's a need, and they've looked at the risk management side of this, and they think they can make it work. A lot of them will have what happens is they will have to cap out, you know, they end up only taking 100 accounts, or how many ever they can handle, and then they have to stop because the compliance part of it on their side is very daunting, and they don't want medical marijuana to be more than, let's say, a third of their portfolio. And it's just the strategy. So what happens is a credit union says, we're going to get into the market, and then rapidly, and it's amazing how quickly this happens, is they will then at some point be closed to new accounts. And then, but also what happens to these institutions is their accounts will, their net assets will triple, you know. But again, it's a lot of money that's coming to their institution, but the profitability, you have to analyze that and say, with all these costs, is this a good idea or not? So, you know, I can't tell you this is a roaring success for them, but I can tell you there's several people that did get into this and are still doing this. Salal Credit Union in Washington, they have 300 medical marijuana accounts. Numerica Credit Union in Washington, 200 accounts, and this happened very quickly. And this is all reported in the press. That's why I'm telling you this. I mean, a lot of the people that do this intentionally still try to keep a very low profile so that they're not the focus of a lot of attention in the press and then by regulators and various other enforcement agencies intentionally. So,
How do even the press get this information?
you know, they're just aggressive in talking to people, and such a good story, and people that really care about what's going on tend to be very vocal about it. It's sort of interesting that it does occur. So,
You need to know that there's 200 accounts at this particular credit union.
Yeah.
I think that's private. You know,
well, yes, and I'm not, I mean, I'm just repeating a press account. So, but it gives you some indication as to what's going on. Now, recently, Washington passed what they called a comfort legislation that was covering accountants and financial institutions. And they were saying that they were going to, you know, do some of the things that I just read about the State Banking Act at a state level. And I don't want to get into the detail of their legislation, but you just have to understand, well, that's all well and good in Washington State, but, you know, federal law is going to preempt that. So the comfort legislation in Washington is very cold comfort. It's not going to really protect them any more than they are currently protected. But it's probably what they see as a step in the right direction. Okay, this is one of the banks in a neighboring state, and I just looked at this a few days ago, and this is what they're doing. Severn Bank in Maryland, it's a community bank, and they're FDIC insured, and they're allowing medical marijuana related businesses to set up a cash-only account. So this is recently, so they're getting into this market. They still see it 70% cash-only basis, but you know, they have established a medical marijuana compliance team. They visit all the customers that with the team before they open an account. They're very strict. Initial fee to apply to get an account, $3,000. After that, it's $1,750 a month, which is steep for some people to even say, I'm going to keep that. But that's what it takes to cover their due diligence, and it's a more expensive account. So that's what they're doing. But, you know, it says cash-only system, but I understand from the reports that they allow, you can't do a loan, you can't, you know, there's no checks that they can use, you can't do a loan, and someone described it as, you know, just cash in and cash out, a place to park your cash. But they do allow for some debit type transactions, some electronic transfers to make payments. And so you can imagine with payroll or vendors or taxes, online issues, that would be very useful. And so, you know, if we had a Severn Bank in West Virginia that was doing this and with this type of program, it may answer a lot of our problems. You know, and this is next door, and you know, they may not have the same risk profile that this state does, but this program alone might be the answer in West Virginia if it was ever adopted and was successful. So I just wanted to point that out. And
How are they getting around that suspicious activity reporting, or is that why they might lose that? That's in their compliance program.
yeah, they still do that. And there's some other things they got to do.
So they report it, they just,
Yeah.
whoever acts on those reports is not.
Well, that's probably right, but you know, that's not to say they couldn't.
It's true of any financial institution, that basically is either state or federally regulated, they're all filing citizen requirements, as far as reports.
Yes.
Are you gonna talk about what the state governments do in terms of depositing of the taxes, permits, things like that?
Well,
Or is that this too?
in this program here, they would allow the use of the debit or the cash only space to pay those kind of things.
Right, but they're saying that the treasurer's office cannot do anything with that received revenue. I thought I understood that the problem was you can't even accept an application fee.
Well,
And so,
the answer to that is simply that that's true in West Virginia. It's not true in other states, but that question may change in other states. It may change when if they have the same risk profile that we do, they may change the answer to that. You know, you can have some programs close in other states. I haven't seen that happening. But what I do expect is all those 390 banks and credit unions serving these accounts, they're going to have less accounts and less banks entering the system. So it's going to be very tough to get an account, even in the other states that are currently doing it.
you're saying no,
Did you want to?
state, the government is asserting that problem in terms of receipt, processing or tax revenue.
That's probably overstated, and I think people would explain it.
Well, two things. One, I'd like to go back to the issue of the account amount, the cost.
Yeah.
With regard to the account costs, those fees generally are for the producers, growers, and potentially dispensaries. But for the patients, in most cases, they're very small fees. When you look at each of the different ones that are being offered, they try to dramatically reduce so that they may be $5 or $1 or $2, depending on what they're doing with that. And with regards to the state, there are, since the rescission of the Cole memo by Attorney General Sessions, there are 3 or 4 banks that have already given notice to their states that they will no longer, as of a certain point in time, accept money through their state program.
And some of those accounts will just get a notice that here's a check, your account's closed. You know, and that's probably happening. So the numbers I gave you are at the high point in January this year, and then you can just try to gauge where it is now. And if I had more recent information, I'd give it to you. But, you know, is Severn at risk for losing its FDIC insurance? They're audited. They have regulators. They file their SARs. I have not seen that happen, but I'm not saying they couldn't. And certainly if they were being sloppy and had some accounts with illegal activity, I would suspect that wouldn't be a surprise, but we just haven't seen that. So we're pursuing the alternative strategies, and we went through that already. I don't want to repeat any of that, but the intention here is to try to give you some ideas of what other states are doing. We can adopt some of these solutions effectively, but most effectively if we adopt the Safe Banking Act, which will make a lot of these solutions easier. And with that, I just want to throw out, see if there's any questions. That's all I got.
Thank you, Chuck.
I think there's another break now, and then we'll check on Rachel's presentation shortly. So. Oh, yeah, I mean, I think we have a 10-minute break, is that right? Let me double check that, sorry. Yeah, 10-minute break, thank you. And, as she said, they'll probably, put their stopwatch on it. Oh. Okay. Someone just went.
I think that I sent stuff over that has, the amendments in there as far as where our rules started. But probably the most important thing, anytime I'm in a room full of lawyers, that I want to tell you about is that if you have questions about complying with the rules of professional conduct, you should call, or email, or fax the question over. We will do our best, our level best to answer it. This has obviously been a long-standing issue that's just, delved into a lot of areas of inquiry and questions. So it's a difficult thing to answer, particularly when you're dealing with government as well. But anytime you have questions about it, you should definitely call. It's best to call before you do it. I strongly recommend before you actually do what you're thinking about doing, you call and ask us about it. And we will give you advice. You call afterwards, it's a different conversation sometimes. A lot of times you did exactly what we would have told you to do. Sometimes you didn't. But either way, it's a good idea and it's a good service and it's free and it's something that you should make sure that you're utilizing as much as possible. The rules do require, if you're going to rely upon this in court and walk into a courtroom and say, I have an opinion, you have to get it reduced to writing. So you would have to send it in, and assuming your letter says what we talked about, we'll sign off on it and you'll have it in the file. It is a good service for you. I do strongly recommend it. The other thing that I want to tell you about is that we do have a website that's out that has all of the rules of professional conduct on it, so disciplinary procedural rules, the legal ethics opinions that are already approved, as well as recent Supreme Court decisions that are out there. We're working right now to finish and finalize our link to the JLAP program. Yes.
Mike says it's getting a little low in volume.
My dress is a little short, so I don't want to stay too close to the camera. The family show over here. Sure, I can raise my voice rather than okay, so anytime Anita and I are together, we take any opportunity to tell you that you should make sure that you understand that anytime you have concerns about a fellow lawyer or a judge or yourself, that you should pick up the phone and call her or Robert Alberry and make sure that you are taking the steps to intervene. You may not know what it is that's bothering the person in your community. It doesn't matter. It's not your job to assess what it is. It's your job to report. So, and it is our job to report. We do self-police. And it's no fun going to lawyers' funerals. And it's no fun disbarring lawyers. Well, but most times it's not. And, you know, the drug epidemic has certainly impacted the bar. And you know, it's a very hard thing to deal with. But unfortunately, by the time I'm finding out, there's not much I can do other than move through the disciplinary process. And it's the end. Because the licensure is the last thing that people are holding on to sometimes. Because you are so high functioning that you can make it, you can get around things, and we can hide from it. And we are a small bar, and we know each other. And nobody wants to hurt the other person. Nobody wants to do that. But reporting to Robert, in the beginning in particular, when you think something's going on with a member of your community, is the best option because it is what can save their life. And possibly their license, but certainly more importantly, their life. I know you're.
It is confidential. You're contacting me or contacting Robert. You are not, no one uses your name. It's confidential to you. Robert will make contact with the individual. The individual never knows who may have called him. So it's absolutely a no-risk policy to you, but Rachel's right. We say something like, we have lost a lot of lawyers in the last 10 years where they maybe could have been saved if somebody called one of us in time.
And, you know, on that with the calling, you know, sometimes I think we get into the bystander effect where we think, oh, this is so obvious somebody called. Just assume no one's called. And make the call. I mean, more than one call is not a bad thing either. So just make sure that you are making the contact. And if it's you, I mean, you should be the person to reach out. But if you're struggling with it, or it doesn't have to be something as sexy as drugs. It could be depression, it can be divorce, it can be anything. You can, in fact, get help through the system now. Okay. All right. On to happier topics of medical marijuana. I really made a bunch of lawyers irate in October of 17 when I advised you right before this happened, right before you all had a conference on it as well, that, oh, by the way, 1.2 prohibits you from advising your clients how to break the law. And I got a raft of phone calls, and then by the end of, like, when everyone stopped screaming, most of them agreed, oh gosh, you're probably right, given that the first iteration and the long-standing iteration of 1.2 of the rules of professional credit was still in scope. Is pretty clear, and that it says a lawyer should not counsel a client to engage or assist a client in conduct that the lawyer knows is criminal or fraudulent, but a lawyer can discuss legal conduct of any repetitive conduct with a client, may counsel or assist the client to make good faith efforts to determine the validity, scope, meaning, or application of the law. That was our original 1.2 rule as it stood in October of 2017. That was problematic because the law had went into effect, I believe, in July 2017, and we want West Virginia lawyers advising West Virginia clients on West Virginia law. And this rule obviously made that almost virtually impossible to do without subjecting yourself to disciplinary action. We are not the first state or the first UDC or the first bar that had to deal with medical marijuana coming into our state. So there were a lot of discussions about how to best deal with the issue. There were legal ethics opinions issued by some states. Maine Board of Overseers started out with a legal opinion saying, oh yeah, it's illegal, but you can do it. Colorado obviously was out at the forefront. They've got some interesting issues in Colorado, including, for Colorado judges, it's still very clear that they cannot use marijuana, medical or otherwise, because they are members of the judiciary. There are states that indicate that with a prescription, you still cannot use medical marijuana because it still would be in violation of the Controlled Substance Act. And just when that was beginning to kind of think that this was the only problem that we had, the United States Attorney's Office came out and said, you know what, I think we're going to rescind the Cole memorandum. So things got a little bit dicey around the December, January mark. But just dealing with 1.2, one of your esteemed colleagues petitioned the court to have the rule changed, which was perhaps what I was suggesting when I said we need an amendment to 1.2 to allow you all to do this. And this, just by the way, I'm dealing specifically with Rule 1.2. Do not think for a minute that other rules are not implicated, that your malpractice insurance can't be implicated, and that your bank aid issues can't be implicated. So I'm specifically talking about 1.2 of the rules right now. But the rule amendment went up and was published and sent out for public comment in January of 2018, and our board did make a public comment on the rule, asking, we thought the rule was actually too narrow. Our suggestion was that you should change the rules for, I think it's Alaska's rules that the court eventually adopted and put out. But our thought was, one, you don't want to put the bill in there just in case there's another bill in that's being referenced. And two, because there would be issues with the banking laws, for example, we wanted to say, by the way, if West Virginia law conflicts with federal law, then you have this obligation to do that. Because our thought was that it wouldn't just be the medical marijuana law. It would be all of these other ancillary laws that dealt with that. So we suggested to the court they expand the rule provisions to what it ultimately ended up being adopted. The court did adopt a new rule, which I'm sure is in your, it's attachment C in ours. And I think it's an effective rule for you that allows you to assist and counsel your client. This rule, our treatment of the rule is somewhat consistent with other states. A lot of them did do rule amendments to allow their lawyers to advise and counsel. It creates the 1.2 essentially allows you to draft, advise, and counsel your clients about laws that are in conflict with federal law. What it doesn't allow you to do is break the law. You're still hamstrung by 8.4B, which indicates that lawyers can't break the law or commit criminal acts. You're also hamstrung by 8.4D, which is prejudice to the administration of justice. The banking laws make things a little bit difficult. There was a reference to Bitcoin in here, and I will tell you that the board is looking at an opinion as to whether or not Bitcoin can even go remotely close to your IELTS account. I'm going to suggest to you that the answer is no, they cannot. There's at least one other state opinion out, and it's an obscure state. I can't think which one it is on Bitcoin. That its fluctuation, making it not real money, has some concerns about coming into your IELTS account in general. So we're at the jumping off point of 1.2 being amended, but it just opened Pandora's box as far as, oh yeah, well, what about this? I do agree that I think the SAFE Act would eliminate a lot of the issues with the need for federal or state banking legislation. I'm just not absolutely certain how close we are to getting the SAFE Act. Either of those.
It's just sort of stuck.
Yes.
Yeah, that's right.
I strongly recommend to you, if you are going to, as I stand here, and I will tell you that, my first priority, particularly when I'm teaching the bar, is to keep you out of my office. We have enough to do. I don't want to begin to have more complaints as they come in. And I will tell you, make no mistake, lawyers who take on this particular area of law right now are taking on a tremendous risk. Those from the ancillary service providers as well as from marijuana businesses, the growers, the distributors, you are taking on a risk, particularly when it goes beyond legal advice. Because I know there are some lawyers who want to invest. And I would recommend to you that you look strongly at the rules, particularly 1.8 and again, 8.4B. Because advising clients and being shareholders, being owners of businesses that are in violation of federal law does further implicate the rules. So make sure that you understand the change that was made to our rules specifically goes to you advising and counseling on how to comply with the rules. With your malpractice insurance, you may want to check and make sure there's nothing in your malpractice insurance that would prohibit you from engaging in this area of law. I don't think that your coverage is going to be one of those things that you want to beg for forgiveness for later rather than ask for permission. That's an aspect, I think, that the potential malpractice claims, whether you're invalidating your coverage by going into the area of law is something you want to make sure about. But again, as the first rule of the rule of professional conduct is confidence, make sure you do know what you're doing. If you're going to go into this or any area of law, make sure you understand what it is that you're advising on. And, it does change on a regular basis. I mean, just from October to now, there's been a tremendous amount of changes throughout the country, position changes in the federal government, position changes in the United States Attorney's offices. There are a lot of things to remain abreast as far as the law changing, and we would expect you as lawyers to remain competent in all of those areas. And you would subject yourself to problems if you were not properly advising your clients. Oh, by the way, you can go to federal prison for running a drug cartel. So make sure that you are very, very clear and very, very competent as to how you are proceeding. And my board wants to make sure that you understand we took no position with the court through either opinion or through any written documents about the use of medical marijuana. It is just how it impacts the rules and how it impacts your licensure. Do you all have any questions about this rule change itself?
One of the things that I think is a good idea is that if you actually would represent medical marijuana related business to have some of these, issues spelled out in the
Yeah.
That if there's a limited engagement, you need to say that. If you're not going to advise them on federal laws, you need to say that. You need to be very specific and limit the scope of what you're doing.
Yes, you can limit, after the rule change, you can limit the scope of your representation in any kind of relationship, but you do need to make sure that it is reduced to writing. The when the rules changed again in 2015, all of your representations, regardless of what you're doing, have to be reduced to writing in some form or fashion. I don't care how it's reduced to writing. Contingencies have to be in writing and signed by the client, but anything needs to be done. And I will tell you that one of the better practices that lawyers employ are engagement letters, and saying specifically what this is. I'm going to represent you. This is what I'm going to do. This is how I'm going to be paid. This is how much I'm going to do. This, and more specifically, particularly in this area, is this isn't what I'm not going to do. The rules do indicate that if you tell a client, I can't do that because it's in violation, that if it is in violation of the law, you need to say, I can't do this because it's in violation of the law. It's in violation of the rules. There are specific rules that require you to communicate that to your client. And I do agree that doing it in writing is the best way to do it. But I also will tell you up front, having been in the office for 16 to 17 years, lawyers don't like putting stuff in writing. But it is in your best interest at this point to CYA on a lot of issues that would come up. And keep updating too. Keep updating your letters as the law changes. Keep updating your letters as the rules change. And as more stuff comes out, I would keep abreast of your forms and how you're educating your clients. What else do you think?
There's no safe harbor for an attorney that's got terminal illness and wants to use medical marijuana.
Take no position on the issue of the use of medical marijuana. It is a it's a difficult thing to be placed, and I don't disagree with that.
What about an attorney that would be a caretaker for someone who uses medical marijuana?
As in, like your spouse?
Yes.
Is your spouse a lawyer?
No.
I'm not interested in your spouse.
And me as an official caretaker, just hypothetically, me as a potential caretaker under the act.
I mean, are we assuming that that your spouse is complying with the state law?
Yes.
Why would it impact you just because you're taking care of somebody who's got a medical prescription? I don't believe so. If you're buying it on Capitol Street, that might be a problem. If your spouse and you were caring for your spouse, no, or a child, I'm not sure that we would. I'm having a hard time envisioning a circumstance to which we would go in, assuming you are not breaking the law yourself.
Well, and if you're a caregiver that's purchasing it, then that's an issue you got to be careful with.
And that was the issue. That was what I.
You're not only taking care of them, you're actually purchasing them under compliance with state law. The federal law would be different, right? You might have a concern with that.
So when it all gets up and rolling, we may need a written opinion at that point to decide whether a lawyer could purchase medical marijuana for their child's use.
I do think that's probably another issue that will have to be addressed, particularly with legal guardian. Because obviously another adult can do that, but you have an issue with legal guardian. It is difficult. I mean, it is a difficult terrain, but it's certainly here. It's, growing, for lack of a funny way to put it. And, I think we are going to have to address it. But the first thing that I thought was such a critical change was that quickly the court readily recognized that West Virginia lawyers needed to be able to advise people on what they were doing. And they wanted West Virginia lawyers advising on West Virginia law to West Virginia clients. And I thought the ease to which they moved forward with adopting it, the 2015 amendments, they were a wholesale change to the rules of professional conduct, and they had not been amended since 1994. So, the fact that a new amendment went through as fast as what it did is a testament to the court and to the court's understanding that you needed to be able to advise your clients on the law. So, kudos to that. Kudos to you for stepping forward and doing the amendment. So I think that's at least given us the ability to talk to people about what they can and cannot do. Because there are other states that have little, difficult things in there that are carve-outs, like you can advise, but you can't draft. And I think, so you can, I can stand over top of you and say, well, write the comma here. But you couldn't actually draft a document for somebody that would be in violation of federal law. And I think with our amendment, which is similar similar to Alaska's amendment. It allows you to be a lawyer for your client and not stand in the shadow and be kind of a pseudo lawyer. It just doesn't allow you to break the law, which I'm not sure that it would be much of a safe harbor for allowing lawyers to break the law. You don't have any questions?
Yeah, and you know, for people that, when they were on there advising them on drug screening, you're advising them about this law, and then there's other areas where this will come up besides advising businesses. And I think it's safe, we've got some time to open it up to any kind of questions.
Yeah, we have just 2 or 3 minutes. If anybody has any questions from any of the speakers, either ask them in this room or send them to me right away. We've got about 5 minutes and then we're going to be out of here, so type fast.
I have a question that's kind of an opinion for Brian and the Bureau of Public Health, because I did not know about the opioid provision. And I am wondering if, I know that, you know, that you all can comment on legislation and things like that, and even propose legislation, but it just seems imperative that the Bureau of Public Health take a stand on that provision in the law, because the requirement to potentially create an addict before making them eligible for medical marijuana is preposterous.
Okay. So, I don't know if everyone, so what is being referred to is in the list of medical conditions is N, severe chronic or intractable pain. It goes on to talk about that in conventional therapeutic intervention and opioid therapy is contraindicated and has proven ineffective as determined as part of the care. So to fall within that particular medical condition, there's got to be a finding that conventional therapeutic intervention and opioid therapy is contraindicated or proven ineffective. So that was a provision that was identified prior to the 2018 regular session. I'll even note one of the members of the legislature who was incredibly interested in this, that's Mike Pushkin from here in Kanawha County. And that was to be removed. In the bill that started in the House, there were several very limited provisions. It went over to the Senate and blew up into lots of various provisions. But that was very important to him, and I think it's important to a lot of folks because it's ironic, as in one of the reasons that has been forward for medical cannabis and the legality of it is that it reduces the need for opioid therapies. So it seems incredibly ironic that the law would require you to at least make a finding that it's not contraindicated or that you tried it and it didn't work. So yeah, there are efforts. That is not one that the Bureau in itself has made any particular recommendations, but I do believe that the Medical Advisory Board has identified that, and certainly when we put forward any legislation going into the 2019 session, I'm certain that will be part of it on behalf of the Advisory Board.
Well, I hope you extend that to the Bureau of Public Health. It is coming from the agency itself. Be concerned with public health.
I believe our commissioner feels similarly about it, and so, yeah.
Curiosity, to your knowledge, is that language unique to West Virginia's legislation?
I believe that's in the Pennsylvania law, but I have to go back and look.
Well, I'd just like to say the use of opioids for 6 months is prerequisite to getting the marijuana. All of my clients qualify.
Okay, I want to thank all of our speakers for coming today. They volunteered their time and obviously a lot of effort. Thank you very much. Another thank you to Chuck because he, as I said earlier, he put all this together. I just got a question on the hours again, so I'll tell you it is 3 hours, 1 point, I'll get it again right, 0.5, three total hours, 0.5 is in ethics. Do not put your time in. Wait until you get the email from Mike. If you don't have the email by 9 o'clock tomorrow morning, then call us. We get calls, when am I gonna get it? When am I gonna get it? It takes Mike a while. We've got over 300 people who are on this program. So it'll take them a while to get it all put together. But thank you all for participating. We have another program that's coming up in July. You still have, if you don't have all your hours, you still have until the end of July to get them in. So you're still legit to take some July credits. We have, in June, we have 16 hours at Flatwoods for basic mediation. So if you're really desperate and you want a good seminar, I don't mean desperate for the seminar, but desperate for the hours, come to Flatwoods for the basic mediation. Monica Haddad does that every year, and it's a good program, tons of hours. And then we'll have another one of these in July. I believe it is July 26th. I strongly encourage everybody to look at the Bar Blast. I'm trying to get one of these every 2 months, live and free. If you watch them, you can get every single hour you need free. So please watch the Bar Blast. If you want to volunteer, I don't mind hitting people up. I have hit a lot of people up to do these for me. But if you have any interest, please let me know in a topic especially. I just did an admission. I didn't do the admission, but we invite all the new admittees here for lunch. And one of the new admittees does beer law. And so he said, get him until January. So next year, we're going to have a good one. We have marijuana and all. We'll have beer next year. So thank you all.